Hey everybody, this is Brandon McGee at the McGee Law Firm, and today I'm going to talk to you guys about avoiding family feuds after your death or after your mental incapacity. Now, this is a really big topic in estate planning. I can't tell you number one, how many clients I have come in that express to me, look, one of my big objectives in creating my estate plan is I don't want my families arguing with each other. I don't want my kids getting into a big bloodbath with each other after I pass away or if I lose my mental capacity. Second, I can tell you firsthand, the legal system here in Texas, the probate courts are full of cases where this is going on within families, family wars. Now, I think we can all agree that the last thing that we want our death to do is to cause our family to get in a big old feud. I think most of us, we pass away, we lose our mental capacity. We hope it will bring our family together, bring them closer, and they can remember us and have things go in a more positive way. But how can we greatly help that along? What can you do to really put your family in a position to avoid these kinds of bad arguments and bloodbaths? The main thing is to have a very well thought out, detailed, comprehensive estate plan. Number one, let's have powers of attorney in place that appoint somebody, our first choice of family member, to make decisions for us if we lose our mental capacity. And then from there, let's have some backups in place. And it's to where it is what it is. You left it in the paperwork. If your family member wants to be mad at somebody, they can be mad at you. You're mentally gone, so it presumably doesn't really matter. What we don't want is our children or our stepkids fighting with each other, right? Second, for the documents that you're gonna have to leave behind for when you pass away, which could be a will, it could be a trust. Check out some other videos to see the differences in those. But whatever document you're going to choose to dispose of your assets after you die, let's be very specific. Let's say this is the person that's going to be in charge. This is my second choice. This is my third choice. This is who's going to get what. And the more detailed you are, the more thorough you are, much less of a chance kids are going to argue or stepkids are going to argue with their stepmom, things like that we see in the legal system. So I really want to encourage you guys to really have that detailed, thorough estate plan, your powers of attorney, your last will and testaments, your trust, if you have a trust device, so that we don't have room for that. Again, like I said earlier, if I pass away, if I have two sons, if one of them is going to be angry, okay, I would prefer my son to be angry at me because I'm gone and I didn't leave him in charge of the estate plan, than for him to be angry at his brother and to get in a big fight with his brother. Because what I see in estate planning is children or stepkids or stepkid versus stepmom, things like that. I see these big bloodbaths that I feel relatively certain the people are going to be so emotionally scarred from what happened that they're probably never going to recover. They're probably never going to reconcile. So that's not what we want, guys. We want to leave our family in our estate in a positive way, and we want for everybody to be able to come together and celebrate our life or mourn their loss, whatever they choose to do, and not be fighting with each other. Now, I want to remind you guys, I do have offices in Southlake and Fort Worth, Texas. However, I have clients all over DFW and, in fact, all over the state of Texas. So if any of you guys are interested in talking to me in more depth about this topic or any other estate planning topics, feel free to reach out to us if you're a Texas resident, and I would be happy to talk with you guys. But you all have a wonderful day. Thank you.